Dennis Bell versus Jesus Miranda, case number 25-02867-CH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court just simply for a status check-in on whether or not the terms that I stated in my last order have been accomplished. So I guess I will go first to Mr. Bell. Mr. Bell, are we in a good spot today?
Your Honor, I'll tell you what's going on. He moved part of the fence, and then he says he doesn't have to move the other part because he said, hey, he didn't care what the court says. He's only going to move part of it. And I told him, I said, do you understand what you're saying? I said, Judge Rossi's, order is gospel. I said, you have to move the whole fence because you got to move the whole fence to have clear passage. So he just moved part of it. When he said he wasn't going to do it, no matter what the court said, I had to leave it alone, Your Honor.
Okay. And when you say there's not clear passage, do you mean that if someone's driving that big vehicle we talked about last time, that now there is a, what I'm going to call a jog in the driveway that they have to navigate?
You got it, Your Honor. When you gave the order, it was spot on, right? The gas meter over to the fence. When he did the first part, it was spot on, and I commend you on that. That was the right thing to do. We opened up the passenger door as you recommended, and it was clear. Then, as we proceeded past the house, right? As you proceeded past the house, now when you go past the house, you can't. It's like you just said, it's jogged. So therefore, that's an accident waiting to happen. A person's going to come out of there, either going to hit his fence or it's going to hit the house, right? So, and I said, listen, we don't have a say on this. Judge Rossi made the order. We just got to follow it. He said he didn't care what the court said. He's going to do what he wanted to do. And you can see the arrogance of what he has just done. He didn't follow your order. He stood me up on the first appointment, and I was over there waiting. He didn't show up. So, Your Honor, I don't know. I'm throwing my hands up on it. I don't know what to do. I mean, if he disrespects the court and disrespects you, then I don't stand a chance. So, you know what I'm saying? And
I hear you, Mr. Bell. Let me hear from Mr. Miranda.
I'm done. You know what I'm saying?
What, his argument is here. I hear the frustration, and I understand where it's coming from. And part of it may be due to, me being very clear about, hey, you got to clear this gas meter, but not necessarily as clear about what we got to do with the rest of that, fence. Let me hear from Mr. Miranda.
Good morning, Judge. I did move the fence as it was written on the order on the nearest place from the house.
Yep.
The one part that Mr. Bell is talking about, you can actually see it on my screen. There's a pickup truck parked in there with the two, with all the four doors open. That's the spot that he's talking about.
Yeah, so a person now they come up that driveway, they can clear the meter because you moved the fence, and then behind you in the corner of the screen, I'm seeing what I'm going to call that jog that looks like it's about 6 fence panels. And the person then has to either, like you got a car parked there, and it looks like that person, you're saying, well, Judge, they can park, they can open the doors.
Correct.
They can access that.
Correct.
And what's beyond that, Mr. When a person drives past there, do they go into like a parking space, or what's beyond that?
Correct. There's a parking space. If I move my fence according to how Mr. Bell wants me to move the fence, then the whole property becomes a shared driveway, and he won't be able to park any cars, period.
And why do you say that?
Because then it'll become a chair park. Then it'll become a chair driveway throughout the whole property, and then he has no private property to park any vehicles.
You're thinking if you move the fence, because then in your view you're giving up more of your property to this easement, and and then, or, or whatever we're going to call the, the driveway, that then you've got a right to use it too, and you're going to be contending with your vehicles going in and out. Now, it doesn't really make much sense. You don't have any reason to park and utilize the house, right?
Correct.
Okay. Yeah. Well, here's going to be
And
my,
there's, I'm sorry.
yeah. Go. Do you have something more to say, Mr. Renner?
No. I was just gonna say that there is enough. There's enough way to go all the way to the house, as you can see on the picture where I'm talking.
Yep. Let me go back to Mr. Bell. Mr. Bell, now I'm looking at that picture. It looks like, though I get it, there is a jog in the driveway. It's less than perfect, probably, as far as driving conditions. It certainly wouldn't meet the Michigan County Road Commission manual for roads, but as driveways go, it doesn't look like it's impossible to navigate. Am I seeing something wrong?
Well, Your Honor, first of all, we do not want this to be an obstacle course, right?
Right.
You know what I'm saying? We
Right.
want to be able to, these tenants, and if I sell the property, they want to come in, park their car, and go about their business. And he thinks that this driveway is his. That's the problem. He doesn't understand what an easement is. It's obviously he doesn't, right? And this easement has been in place for 40 years before he bought it, before I was over there. So now all of a sudden now he wants to come in and take part of that easement away. I
Was there always a fence there?
never
Uh,
was a fence.
there always was some kind.
No, it never,
Oh, it was
no.
just open land before.
Yes,
Yeah,
yes.
I see.
Yeah, it's been there forever. And
Yeah.
yeah, and now all of a sudden you come in and you know what a prescriptive easement is. If it's been over there 15 years unabated, it becomes permanent because that's the way these people were using to get to the backyard. And now, no matter what he says or what I say, you can't overstep the boundaries of what the definition of it is. So,
Yeah.
for some reason in his mind, he thinks that property is his. Now, Your Honor, I got to say this. I don't care what happens after that. He can gain property. You know what I'm saying? He can have whatever's over outside that driveway, and he can have whatever property for whatever his lot is. But we definitely can't have it as a hindrance to the tenants, is what I'm saying. Now look at that. That looks terrible. You come in there, you're going to hit that fence, Your Honor. I promise you. You're going to eventually, somebody's going to hit that fence, or they're going to hit the house. There is no question about it.
Well, and of course, if they hit the fence, because Mr. Miranda's fence, then he's got to, that of course, then the person has to deal with their car damage.
Yes.
But, that he's got to figure out. I mean, to some degree, he's taking the risk. You're right, because I would agree that corner does present.
Awesome.
At least, I could drive my little Chevy Volt through there 100 times. You ought to see how tight it is to get into the courthouse because we got a. It was built right after that Oklahoma City bombing, and they made a real tight turn to go in to make sure we're safe with
Yes.
the bike. But I'll tell you, you don't want to be driving a full-size pickup into our
No.
courthouse park, and it's tight
No.
as can be. So, well, here's, and I again appreciate, both parties have come in here, and you're following the law and doing this thing the right way. You're not resorting to self-help, which I appreciate. However, my order at this time is, another nature of easements in general is there is a rule that goes along with them that say they should be enforced by the law in a way that's least burdensome to the person losing property, who in this case is, it's not a person, as you point out, Mr. Bell, losing property. Really, this is an easement that's existed for a long time.
Right.
It's been, arguably in place long enough to be a prescriptive easement. But an easement nonetheless is a permission to utilize what they call the burdened property, which is Mr. Miranda's property. There's a second principle that goes along with them that says, well, when you grant an easement, that it should be in the way least burdensome to the property that's burdened, because after all, we're saying here that the easement works at taking of what would be the surveyed property line and allows, in your case, access to a rental property. However, and you identified last time the fact that, hey, there's a choke point there by that gas meter that just simply isn't wide enough to allow passage of even a wide car, and thus, that's never going to be rentable. And I ruled in your favor there. This time I'm going to go the opposite and say, though, that this isn't ideal. It does allow access. Mr. Miranda did put up a picture of a big truck there with its doors at least part the way open, even at the narrowest point of the driveway. So my ruling is that he's accomplished the purpose of that, easement that you're arguing for. And after all, another thing that happens here is when a fence goes up, for example, that serves as sort of, an acknowledgement to the whole world that, hey, now this easement is here. It's acknowledged by both parties, and this is going to be the line of it. I understand Mr. Miranda is wanting to protect as much of his property, even though I understand the argument there is, well, he doesn't really utilize the other end of the property. There's not that much burden on him if the fence is, 3 feet farther, 3 feet not. Nonetheless, he is giving a portion of property through that law of prescriptive easement so that you can and your tenants can have access and your business can be conducted. But I'm not going to modify the order again. He has, in the very basis sense, complied with the order because I said it's 12.6 from the meter. I didn't say about the rest of the driveway. It does appear to be passable, which is the overall intent of the order. So at this time, I'm going to decree that the order's been complied with and close the case. I know that's not exactly what you would like, Mr. Bell, and if you wish to approach me to reconsider it, or you think there's more relief to be obtained here, like I explained before, the trouble with that is, it's all a matter of weighing and balancing cases. I have had cases involving easement and lake access and stuff like that they drag on for years and they cost tens of thousands of dollars. And, and I always ask the participants, well, you got to say, here's the value I'm getting out of this. Is it equal to the cost of enforcing what I believe are my rights? And I believe the base right here, which is safe passage, onto the rental property for parking, loading, unloading, etc., is protected. So I'm going to rule that it's been complied with and close the case. And again, gentlemen, thanks for bringing this before the court as opposed to going out and taking matters into your own hands. Go ahead.
Well, there's several cases now, Plymouth Canton versus Cryer versus Prost in 2000, that said that if someone uses a neighbor's land openly without permission and continuously for 15 years, they earn the legal right to keep using it. Also, too, it goes on.
No, I enforce that against the church up in Northwest Grand Rapids. I believe in easements, even at the detriment of probably a whole congregation now that is going to vote against me in the next election. So
no, they probably won't, But also, too, it goes on to say, Your Honor, Matthews versus the Department of Natural Resources in 2010 said a prescriptive easement becomes permanent after 15 years of use and passes to future owners. Also, too, Your Honor, in 1997, Sherwood versus Burrow said you don't need to be the only user, just open adverse continuous use for 15 years, that becomes permanent. So anybody who comes in and puts a fence down the middle of that driveway is really going against the Michigan state statute.
Yeah, they're the ones that are doing the taking. Well, here's the issue with easements and my the way, because I've and another thing I got to say here is I never practiced real estate or property law, as a private lawyer. I only touched on it in a few cases, and I did take it in law school because it was required. And since I got this job, I get a lot of real estate cases. I wish I'd listened better to my professors 30 years ago. But the fundamental issue I experience with easements is, of course, first of all, you got to define, what's the easement there for. And in your case, it's pretty clear. It's a driveway. It's not a road. It's not a two-way traffic or anything like that. It's a driveway that'll allow access to your property. And then you know, what is, and obviously, you know, I had a case involving some lakefront property where a guy puts a plate structure right across the other guy's easement, you know, so he couldn't drive a vehicle down it anymore. Well, you know, that obviously, you know, then you make the easement unusable. Well, you know, that the other corollary of that law, like I said, when you're defining the scope of the easement, that is how wide that access road is. Because, you know, usually when people are utilizing it in that open and notorious way, they're not, you know, they're not putting down curbs and lines or anything like that to define the width of the easement. Then the court has to define it as a reasonable width. I'm saying the reasonable width here is to allow access. It's not, you know, in quotations, perfect access, but you know, I also live in East Grand Rapids. I think I've had to make tighter turns than that to get into my own garage a few occasions. You know, it's not unknown that you have a curve or a jog in an access driveway or road. So I'm going to stick with that. I understand where you're coming from, Mr. Bell, and frustrations with it. Just know that I share those frustrations. There are about a million cases
Yeah,
out there on
we,
easement and
yeah, we
property
respect
law.
that. We respect,
They're,
no, we respect you know, but also
I
too,
wish it
Your
was
Honor.
more crystal clear.
Oh, yeah, also too, Your Honor, we never did address the damages. Do you want can I take that up in small claims, or do you want to address it,
Well,
or
I thought
because
that I said right, that because Mr. Miranda did move this, and you know there was some argument, but the original mediator's order didn't contemplate an award of any money to either side, that I was going to stick, because at the end of the day, I'm trying to enforce that and clarify the original
true,
mediator's
I
order.
understand that. I do. I understand. No, I respect that, but we never did address that. So what I'm saying is I should have the right to address that. I don't know under you or in small claims. I still, because we did suffer, Your Honor. We
Yeah,
really did.
well,
I mean,
and
we did.
yeah, I guess the answer is if you think that you know it wasn't adequately addressed or unaddressed
It
by
wasn't.
my order enforcing the mediators, and I don't have the mediators, I just have my order in
Okay.
front of me now, that you can bring it back. I don't think it's a perfect claim. I think it, you know, may get attacked on the fact that, hey, we worked this all out before, because usually when you get an order in a mediated case, you know, the goal is to resolve all of the issues
Yeah,
arising
which
out of that. However, I don't
we-
want to opine on the breadth of that opinion right now. I don't have it in front of me. So,
okay.
uh,
So we can bring that later, you said? Because we
well,
definitely suffered,
I'll
Your Honor.
leave that to you and your attorneys to do an analysis and see if there
Okay.
is anything worthwhile
He
to
did
do.
say we had a case, Your Honor. He really did, because whenever you start losing money because a person puts in a spite fence, and we really do believe it was a spite fence without any doubt. I mean, and spite fences do get awarded damages when that is happening. And this was a spite fence. Even the city of Grand Rapids talked to him about putting the fence down the middle of a shared driveway, which caused my tenants damage, caused me financial damage.
Yeah, I
So
remember you said,
yeah,
right, it
no, we
came
have a
during
case.
a
Yes,
tough
we
time
do.
because you didn't feel like you could raise the rent when they're struggling to access the house,
Right?
and I get that, and there is economic reality, and
Absolutely.
the only thing I can warn you about, Mr. Bell, is sometimes enforcing, you know, especially in a court of law, gets more burdensome and expensive than the money you get out of it. So,
Uh,
but I'll leave that to you to do that calculus. You seem like a person who's more than capable of putting
yes,
a
we
couple of
are.
facts together in your head. So.
We can put that. Hey, y'all, and here's what I need to ask you. Can we bring that in small, or do we have to come back to you?
No, it would be a separate case because I'm going to close this one today.
Okay, yeah. So therefore, we can bring that. We don't have to come back to you. We can go to small, right?
You do, but you're still going to have to contend with any, you know, arguments that it's already worked out in this case. So yes, but you could bring it into small claims court, and
Okay.
you
Because
know,
you're
And
going
I,
to close because you're going to close the fence portion out, and that's the only thing that we're going to address today. Is that correct?
yeah,
Okay.
I'm closing out with my, you know, I'm going to say my order's been completed and close my case, and therefore, you know, and then that, you know, what we do in every legal case is it creates a record. You know, there's a paper
Yes.
record that includes that mediator's order, my order enforcing it, and then my closure. And then, you know, from a legal standpoint, that gives you whatever rights or, you know, rights that weren't addressed in the case.
There you
Uh,
go.
could still
Okay,
be
yeah,
open. So
because, yeah,
that's where we stand at the end of
okay,
today, and I'll let you and your lawyers analyze the next step.
okay, thank you, Your Honor,
Can I
appreciate
say
it.
a quick word?
Yeah, go ahead, Mr. Miranda.
Uh, I just want to say that he tried suing me through small claims once before, and the judge dismissed it.
Well, and that could happen again because, as I said, one thing that we do pretty well in the courts is we give effect to other courts' orders, and at every level, but especially at the small claims and district court
Right.
level, every judge is swamped with more cases than they can deal with. So if it looks like another judge has issued an order that encompasses what's being argued about, usually that other court will enforce the order, but that is very dependent on the language of the order, and I've already
Absolutely right.
issued
You're right, Your
my
Honor.
order here. So
This was about the case that was dismissed as the one you're handling, because you're right, we had to come to circuit court. That was the issue. You're right.
right.
You're right. It was
So
circuit
yeah,
court.
nope. And I don't want to, I don't want to get out of my lane here. And
No,
talk
you're
about
smart.
what
You're a
might
smart
happen in
man.
another
You're,
court. So.
you're a smart man. You know what you're doing.
Yeah, that's one thing I have learned. So, all righty, gents. Well, I wish
Thank you.
both luck, and as I say, I really appreciate you turning to the courts instead of a sledgehammer. That never works out well for anyone. So,
Thank you, Your Honor.
thank you.
All right.
Thank you so
Bye.
much.
Bye. Oh,
And this matter comes before the court this morning on Ms. Corbett's motion to withdraw her plea or for judicial vacatur of the guilty plea. At this time, I would invite counsel to place your appearances on the record.
Blair Lockman for the people, Your Honor.
Thank you. And Ms. Dagger Margosan, you are muted.
I'm sorry. I'm Janice Dager Margosian for Ms. Corbett.
Thank you, ma'am. And this is your motion. I did read through it, and it appears that the primary basis here is that the factual basis that was elicited during the plea hearing itself did not meet the elements of the charge that Ms. Corbett has pled to and is serving her time on right now. And that specific statute is accepting the earnings of a prostitute, MCL 750.457. And I did read through your brief and the prosecutor's response, and I guess my view of this, particularly in light of the appellate cases that set a somewhat relaxed standard for a judge accepting a factual basis, is I certainly viewed the entirety of the transaction that Miss Corbett was involved in with these customers coming to the massage parlor as a transactional situation where the customer comes in, they pay Miss Corbett the $50, allegedly for the room, but let's be honest, under the facts of the case, it is for access to a room with a young woman who's going to perform a sexual act, and everyone has knowledge of that. And then, she accepts that money. It seems like a stretch to say that's not the earnings or proceeds of prostitution.
Can I respond, Judge?
You may.
Thank you. Well, number one, Judge, I think it's really important here. In light of, and I think the Maury case is really important, that you really do have to look at the language of the statute. Here, Ms. Corbett did not stand there and accept these door fees. So number one, I think the important fact is they were door fees. They were not money obtained from a sex act that was performed. And she was not present at the premises at the time she collected these fees. She collected them at a later time, at a different time, when these sex acts were not going on.
Well, let me just pause you. She wasn't the landlord of these premises. That was someone else. She leased the premises, and this was her business, right? Whether she was present for every moment, and certainly I think everyone agreed, well, she's not present in the room when the sex act occurs, but that rather it was a scenario where she knew and allegedly, perhaps, to some degree, trained or, prepared these women for the nature of this illicit massage business, right? And further, I don't think that the statute doesn't say you got to be standing there and the prostitute commits the act of prostitution while you watch it and then hands you a portion or some of the money. It just says that the person themselves knows what's happening and then they accept, receive, levy, or appropriates any money or valuable thing, from that act. And I guess the other piece of that is without any consideration given to the person, presumably I'm trying to figure out what in the heck the statute means by consideration here. And the only sense I can make of it is, you're not giving any consideration back to the person who performs the act, but rather you're just taking the money or a portion of the money that comes from, results from the act in a broad sense, the proceeds or earnings. So, I mean, I guess, and that's really my thought in looking at the statute entirely is you'd like me to, impose like a sequential order that has to happen in time. And the statutory language to me reads much more broadly than that. It says, hey, if you get your hands on some of this money and you know where it's coming from, you're liable, that's what imposes jeopardy under the act. Am I reading it too broadly?
I think so, Judge. Respectfully, I think that, and this is what happened in the Maury case, is the Supreme Court looked really, really closely at the words of this statute. I think here you would have to have a situation where Ms. Corbett was receiving money from the prostitutes and knowing at the time she received it that that's what it was from particular sexual acts. Here we don't have that. We have a very generalized set of door fees. So I think the area we're treading into is what the
Maury was a little
prosecutors.
different though, because it was the person was more or less who at least, and I didn't read, I just read your summary of Maury, but it sounded like that was a scenario where the person was receiving the calls and then directing the customers to a location to meet with a prostitute. And if there was any money changing hands, it would have been, a separate transaction or not, and in that, is that the kind of the
Well,
background of Maury?
I think, and I summarized Maury as well as I could for you in the brief, but I think the important part of Maury and what happened at the Michigan Supreme Court level is that that court said every single word of that statute has to be observed and complied with by the courts. And we can't, this is the kind of case where you could make inferences upon inferences upon inferences, which the prosecutor relies on in the brief, talking about inferences. But number one, this is a plea, so you got a due process concern of making sure, because you're not having a trial, you're not having a jury find these facts, that the defendant is establishing this guilt. And number two, where the inference upon inference, the old rule of Attlee, I believe it was loosened up in a case called Hardin in 2002, which still said you must have findings that are based upon evidence. You can't speculate. And in this particular case, we're in the realm of speculation. There were door fees collected. Ms. Corbett was not there to collect those fees. She didn't know what was happening in those rooms. There may be times certain things didn't happen. You don't have a transaction where a prostitute goes into a room, does an act, comes out, and turns over her profits. And I think that's, this statute, I think, derived from the times when there were where prostitution was developing.
Right.
And so you had pimps that were taking fees one-on-one. You don't have that in this case. You have a very generalized setting that she made available. She didn't know what was happening in those rooms. The statute says knowingly that the acts must be profited from knowingly. She didn't do that. She provided a premises. It was known that in general this happened, but she didn't have a one-for-one knowledge that the money she accepted was happening. I don't think that there can be a reasonable inference here. I think you've got inference upon inference upon inference, and I don't think that that has any place in plea proceedings, Judge. That's a violation of due process. So that's the summary of my argument.
Well, her own attorney asked her, and I'm on page 9 here of the plea colloquy. Mr. Fabian, you're aware that at least one or more of these independent contractors would perform sexual acts during the massage and in exchange for money.
Correct.
Corbett, yes, sir. I mean, how's that not acknowledging that she knows what's happening in those rooms, whether she's on the premises at the moment or not?
Well, but I think that again, what we've got here is a generalized situation. So she is stating that she knows generally this happens. So that would certainly, we would agree, supports having a house of prostitution. She knew this happened, but she wasn't taking earnings as they occurred. She took a very general door fee. The women that did this work got some kind of tip. We don't know how much was tip. We don't know how much was door fee. This was not placed on the record. And so I think that where you have to have some kind of specificity with a plea that complies with the statute, we don't have the knowingly element and we don't have the transactional element. I think those things are clearly missing here.
Okay, all right. No, I think I understand the argument. Let me see if Mr. Lockman has any response in addition to the brief filed.
I would just note, under that theory, we would never be able to do this charge, because they should argue that they have to know specifically that every dollar that comes in is for this, and that's not what the statute contemplates. I think the court hit the nail on the head. It's right in the brief. She acknowledged that these were independent contracts performing sexual acts during the massage in exchange for money. I don't know how you get more specific than that. And I don't think the courts require more specificity than that. And then she admitted that she collected a fee from every customer that entered there for, in quotes, massage service, which she was aware in many cases were for performance of sexual acts. I think this is, I think it's someone who, after sentencing, has decided they didn't like their sentence and is now looking for a way out and finding this defect. This is not a defect. This is a very clear factual basis that she knew what she was doing, and accepted that fact when she took that plea. And now she's just having buyer's remorse.
Okay, all right. Thank you,
Your
Mr.
Honor, if I could just place on the record, I appreciate that. I hear that from prosecutors pretty often. We don't have any evidence that this is buyer's remorse. What this is someone who had the right to have an attorney overlook her case and view it and see if there are possible issues that were overlooked at the trial level. I don't think disparaging my client is appropriate here. So just want to address that.
Oh, no, I understand. And of course, my entire job is to make sure that, each person that comes in front of me gets the full range of procedure they're entitled to. And a hearing like this is just that. So I don't attribute any of it to, some sort of ill intent on behalf of your client. I know, and I know that you're simply doing your job here as well, and going over the proceedings, as it needs to be done with a magnifying glass to make sure that I get it right, because heaven knows. I was just thinking the other day, when I elected, one of the promises I never made was that I would be 100% perfect judge. I just said I was going to, fulfill the oath to the best of my abilities when I'm on the bench. And I appreciate the ability to, legally consider what I'm doing here. However, I will say in this case, I have read the briefing, and reviewed the statute, and I don't find a basis for withdrawal of plea or vacatur of my judgment. That would require, finding of a fatal defect, as it were, in the plea proceeding. And essentially, the defect alleged here by Ms. Corbett is that, Judge, you're allowed to draw some inferences in the factual basis of your plea, but you went beyond drawing an inference. You went to rank speculation, as we would call it in the legal world, as to what Ms. Corbett knew, and further as to the sequencing or the economics of the business that she rendered, or that she operated on Plainfield Avenue in Grand Rapids, or Grand Rapids Township, as it were. And the statute at question here that Ms. Corbett entered a plea to was Michigan Compiled Law 750.457, which reads, any person who knowingly accepts, receives, levies, or appropriates any money or valuable thing without consideration from the proceeds of the earnings of any person engaged in prostitution, or any person knowing a person to be a prostitute, lives or derives support or maintenance in whole or in part from the earnings of the proceeds of the prostitution of a prostitute, is guilty of a felony. Now, and I agree with Ms. Dager that statute probably comes from an older time when the law contemplated, perhaps the classic pimp who's out there with a stable of women, and the woman is involved with prostitution. The pimp perhaps provides banking protection, but also appropriates a portion of the money she receives from prostitution acts. And that's not what happened here, though certainly, like the classical situation, Ms. Corbett did provide, the location, the surroundings, and I think that at least during a portion of her own allocution during the sentencing process, indicated that part of her basis for doing this was she had been involved with or observed another business that didn't provide what she viewed as adequate protection for the women that were involved here, and perhaps allowed the customers to pressure them or persuade them to perform additional sexual acts that she thought was unsafe and improper. And so she builds a different business model, as it were, that she believed provided more protection for the women involved. Now, and as I said during the sentencing, the law doesn't make any distinction between sexual acts, and we do have case law out there that says, of course, sexual acts include manual stimulation, as appears to be the primary sexual act we're talking about in Ms. Corbett's situation. It's a very broad definition, and I think that broad definition, of course, in performing what we call statutory interpretation, it's important to read the statute word for word, and I agree wholeheartedly with Ms. Dagger. Part of that is giving effect to each word of the statute, and then trying to discern what was the legislature's intent when they passed the statute, perhaps in an outdated time, or before we had stuff like the internet and instant messaging and stuff like that that changed every business model, not just a business model for prostitution. And in this case, the statutory language is actually quite broad, because it says that any person, and it gives also a broad definition here of how that person receives a financial benefit. They accept, they receive, they levy. Levy, of course, I associate with taxation. Of course, that's not what happens here, but nonetheless, they're or appropriates, i.e., that would be the appropriates, the pimp going to the prostitute and saying, hey, you hand over the money to me. That's not what happened here. However, in a transactional sense, and I also look down here, the person takes without consideration. That is, they're not giving anything necessarily back of value to the individual who they get the money from. from the proceeds of the earnings of any person engaged in prostitution. Now, read in its absolutely most narrow sense, that could include a time factor, and that the person has to commit the act of prostitution and then hand the money over in that classic pimp model that I talked about earlier, which was not what happened here. Here, the timing sequence of these men patronizing this business is they come in, they pay the money to the house, the door fee, for the room, for access. Well, and let's be honest here, they're not renting a room, to use the computer in that room to, do drafting and print out a 3D model or something. They're renting a room with a bed or massage table or something that they know contains a young woman who they believe, because of the way that they learned about this business, will provide a sexual act. And Miss Corbett did testify, she's aware of that. Was she aware of the exact act and the back and forth between the customers and the woman in the room? No, but she was aware that there was money exchanged in those rooms in return for sexual acts. And I think that taking the broader reading of this, that the earnings of the person engaged in prostitution, well, after all, the reason that the men are coming to the business in the first place isn't to get that room for an hour, isn't to lie in the bed for an hour and talk to the woman. They are coming in to, at least in some instances, and it doesn't have to be every instance. In fact, it probably only has to be one instance to fulfill the statute. In at least one instance, the person is coming in and engaging in an act of prostitution. And in my view, in light of the way the transaction occurs here and the use of the word proceeds in the statute, that there's a broader transactional view here, and that in terms of the customer coming in, they're going to pay $50 and they're going to give whatever they give to the woman inside the room, and the entirety of that is to facilitate or enable or make happen the act of prostitution that occurs. And I believe that is a reasonable inference for the court to make during the plea colloquy and during the acceptance of the factual basis for this conviction here. So I don't think, in other words, that there is a time sequence that the proceeds have to be given first to the prostitute and then the prostitute has to give some to Miss Corbett. I believe that the overall basis of the transaction, even though that's not clearly spelled out in the statute, is one that facilitates prostitution, and that the earnings that were paid to Miss Corbett, that is for the room, the access to the woman. And after all, she didn't just say, hey, I set up this business with 3 rooms in it. And, there happened to be women that came in here and wanted to do, massage and et cetera services. But rather, her testimony was she formed this business for the purpose of, creating this environment where, the sexual act was provided in a way that she believed was safer for the women. So I don't think that I over read or applied the statute overly broadly in this case. I think the statutory language can be read and should be read as encompassing this entirety of this transaction that involves, after all, at the end of the day, it is transactional. The customer comes in, they pay money, albeit to 2 different sources, one for the room, one for, perhaps more money in the directly in the room, negotiated with the young, the woman in the room herself. But nonetheless, the overall transaction is one that facilitates a sexual act in return for money. And Miss Corbett knew that was occurring. So I don't think that is an overly broad reading of the statute, nor do I think it supports the type of defect that would allow vacatur of the plea by me at this time. Thus, I'll allow the plea to stand and the motion is denied.
Thank you, Judge. 2 things. I'd be glad to do the order and submit it to you for signature, the order for denial.
Very well.
And then I can serve that to the prosecutor if that's acceptable.
We presented just a general order It's just a standard blank.
You want to do that?
Oh.
Okay.
It's the court already has it. Yep.
Oh, it is. Okay, good.
Yep.
Okay, so the order's taken care of. Number 2, could I have a few minutes with Ms. Corbett in a breakout room, please, before we sign off?
Certainly.
Okay.
Talk to my lawyer for a second. Thank you, sir.
Thank you.
Blair, I didn't get orders today, just to let you know.
I sent them yesterday.
Oh, you did?
I emailed them 4:30 yesterday.
Okay, I didn't see them, so,
Do you want me to? I'll resend it, but yeah, I sent it yesterday.
okay.
Yeah, well, I told Tiffany I'd do these, and once I did, I sent them to you.
Wendy's doing the job of 2 people.
It's fine. It's not very complicated to resend.
Okay.
I thought I'd make Wendy proud of me by sending them early.
Yeah, I just must have missed it, Blair.
I always try to get them to you when I'm on them. I'm going to send it right now. That's that one. Are there any others we have?
I think I can do the other ones.
Well,
Yeah.
I have, I think there's only 3 of them that I have them on, but I'll send them to you right now.
Okay, thanks. We are
Morning.
here in the matter of the people of the state of Michigan versus Marvin Brock, case number 25-07613-FH, and this hearing is being recorded on Zoom and live streamed on YouTube.
And Mr. Brock comes before the court today on a motion to set or reinstate bond in this matter. And I'd invite counsel to place your appearances on the record, beginning with the prosecutor.
Blair Lockman for the people.
And Tamara Lopez on behalf of Mr. Brock.
Very good. All right. And Ms. Lopez, I do see this, and I did receive a bond report from court services that states that, one of the issues that appears here is Mr. Brock looking to become a trustee within the jail and obviously needs a bond in a certain amount so that they can determine his eligibility, and that court services is not opposed to a bond being set. What is the bond you're looking for at this time, Ms. Lopez?
Actually, I put 50 in my motion, but I was incorrect. I contacted the corrections office and they said it's 15,000 to be a trustee.
Okay, and court services thinks it's not more than 25,000. So apparently there's a lot of information out there on that bond amount for a trustee.
Yes.
Basically, you would ask, it sounds like if I set it at 15,000 cash surety, he'll get what he wants in terms of being able to be a trustee, and
Correct.
I can be assured that he still has a bond. All right, Mr. Lockman, what's the people's position?
Well, my only major concern is he's got 3 cases, so would the court be setting them on all 3 cases at 15,000 cash surety?
I only have 2 cases.
I have one that says open for trial. I have a possession of meth, delivery. Oh, because is there a new one? Hold on. I have a possession of meth, a 25 case that's set for trial. There's a P-Wid meth.
That's a new one
From
from November.
Okay, so then, yep, that's a status conference set on that one. And then I have another possession of meth. Your office was assigned. Billy Kuhn had it. It is. So yeah, he waived his PCC a week ago. Oh, I'm sorry, a month ago.
Why wouldn't they give that to me?
Yeah.
Okay.
So Judge, that's my concern is that he's got 3 files. One's a Class B felony, and I understand he wants to be a trustee, but and I doubt he'll make 15,000 cash surety on 3 separate cases, but he's now looking at a Class B felony, consecutive sentencing. If this was 1 or 2 cases, I'd probably be okay with it, but I just think that the risk of him getting out there and reoffending, we're not doing him any favors either.
I think it's other
I
bond.
understand the concern here, but I also gather as well that he did qualify for the defender's office, probably indicating that he doesn't have a pile of $25,000 lying around the house anywhere. So
well, my question is too is will they, with 3 cases, will they let him be a trustee? But I guess that if that's bond driven, that's bond driven. But I mean,
Yeah, that appears in a closer reading of my bond report. They say all bonds need to equal not more than 25,000. So there is, it could be that, right, the cumulative
yeah,
bonds in three different cases. And I don't even have, it doesn't sound like the third case. Uh, at least I haven't even
it,
addressed the question of bond in there yet. Does he have a bond in that case, Ms. Lopez?
I didn't know he had that case. I'm sorry.
it's their office assigned it to Bill Coon, which is why she may not know. But yeah, I'm opposed to with three cases, one of them being such a high severity, to having a combination of bond being 15,000 cash surety. I mean,
I
he's not,
believe
he's
the
not,
Class B one is 10,000.
yeah,
That's what,
it shouldn't have been. I'm sure I can name the judge in district court who did that, but yeah, at this point, he's looking at consecutive sentencing 3 times. I mean, triple stack. Not that he's going to get that. I'm not saying he is, but he just keeps reoffending. It's the same substance, the same offense. I think we're setting ourselves up for failure here.
Well, yeah, no, and I get the concern on your end as well, Ms. Lockman. However, I also look at the economic reality of this. That right, if these bonds total up to 25,000, he's unlikely to be posting them anytime soon. So what I'm going to do here is on the PWID case, which is in front of me, I'll make the amount of the bond $15,000 cash or surety. On the possession case, it's also in front of me. I will set it $5,000 cash or surety, and then we'll have to deal with the third one. We'll just have to figure out what that is. You may be in front of me again if he really wants that trustee status, and that bond's more than 5,000 cash or surety. You know, he still might be ineligible. I just simply don't have that in front of me to set it at this time.
okay.
I'm looking at his court services report to see if it lists
They
a
got
bond
bond on the
amount.
third case.
Um,
Yeah,
How come we don't get the court service report?
I don't know. We don't get them on every case. We get them
Yeah.
on, like sometimes they show up, sometimes they don't. But I'm just trying to see.
They're for the court's eyes only, Ms. Wolf.
I guess.
It doesn't seem to list, and I don't know why they wouldn't. But it doesn't list what the bond is.
Yeah, no,
I'll look into that if we have to
we
do
have to
another
do
motion.
another motion and
Yeah.
get it all straightened out. I am in favor of him being, oh, and to add to his order there, if he does post, I would like him placed on the GPS tether and under a house arrest situation after his release. So I don't want him out there
Okay.
seeking and perhaps selling, reselling meth again. So
Sounds good.
very good. Thank
I
you.
appreciate it. Thank you.
Yep.
And this matter comes before the court today on the defendant's motion to strike certain attendant care claims in the plaintiff's complaint. And gentlemen, I'm going to turn off my screen for just a sec and go grab the stack of briefing on this. I'll be right back with you.
Sure. Thank you.
All right, thanks, Johns. This was one of the larger stacks of paper, so I set it off to the side so I would be able to keep it together this morning. And why don't we start by counsel placing your appearances on the record?
This is Steve Goethel, Your Honor, on behalf of plaintiff.
And Tyler Anderson on behalf of defendants, Your Honor.
Very good. Thank you, gentlemen. And what is at issue here, at least it appears to me, in this is a, you know, in my mind anyways, a recent statutory change and then a fairly recent Court of Appeals opinion where I commend the Court of Appeals for actually having the courage to publish an opinion in this Nelson versus Beaumont Health, you know, giving me some traction to be able to at least rely on it rather than as advisory as I do with an unpublished opinion. So I'm grateful for that guidance. And what I'm seeing here is defendant is saying, Judge, we had, you acknowledged that the family provided attendant care to Mr. Freeman because, there wasn't anyone else to provide the said attendant care to Mr. Freeman. And however, like one would expect in a lot of those family situations, while that attendant care was occurring, they didn't submit a weekly, monthly, annual bill to Mr. Freeman saying, by the way, we're doing this, but it's not out of the goodness of our heart or the familial relationship. It's rather, I'm billing you for it, and you owe me $12 an hour or $20 an hour or whatever that might be. It wasn't that kind of transaction, and thus it's not eligible under the statutory language for to be part of plaintiff's claim. I shouldn't take any evidence of it.
That's right, Your Honor. I think that's what the Wrongful Death Act and Section 1482 unambiguously say is actual, the damages available are actual damages, dollar amounts actually paid. Now, to the extent any family member was a plaintiff, for example, and took care of Mr. Freeman and lost work wages or something like that, that's different. That's a potentially compensable loss, depending on if that's proven. But just
because I think here the spouse said that at first she was able to do it and take some family and medical leave, but eventually she ran out of leave and lost the job out of the deal. You're saying that that's not foreclosed to her. The compensation for her lock, that is a category of damages that would be available. It's just that she's not entitled to compensation for the doubtless many hours she spent at her husband's side providing, what are in medical, because she got trained in how to do, some of these types of care. But nonetheless, she was doing it out of, her spousal commitment for him, not expecting any payment.
Yes, Your Honor. Frankly, the valuation of the care is based on professional services, and nobody's hiring Mrs. Freeman to perform those professional services outside of this situation, right? So her actual loss is what her wages would have been had she continued working and did not have to care. I mean, to the extent that those damages can be proven, of course, but that would be under these two statutes that control here, an actual loss or actual damages that you can verify actually paid or liable to pay. Here, nobody is liable to pay the almost $1 million for medical care, and that wasn't paid. There's a lien for $725,000. That's not an issue. That's actual damages, as Section 1482 says, are compensable.
Okay. All right. And let me hear from Mr. Guthel in response. Mr. Guthel, you've got some pretty definitive statutory language to deal with, because it says dollar amount actually paid for past medical expenses or rehab services expenses, or the amount liable. And I think you're not saying Mr. Freeman actually paid, or any of these people were actually paid and are now, Mr. Freeman's estate is seeking compensation for that. Well, I think that where you are is when the services were provided, Mr. Freeman and his estate thereby became liable for them. You've stated we provided this 24/7 care, and thus we think that some $900,000 in compensation is due and owing to qualify under the statute. Is that accurate, Mr. Goethel?
Your Honor, that's partially correct, but the issue that defense counsel has not addressed at all, and quite frankly, you have to acknowledge, is the second prong of 1482, which preserves liability for medical expenses for which the estate remains liable. That's the second prong. And in this case, first of all, there's no question that this man required 24/7 care. There is no question that these services weren't provided to him. There's no issue over that. What defendant is trying to say, they're trying to convince you that the only damages that can be incurred here are ones that are actually paid. And this whole argument about Mrs. Freeman's wage loss, they didn't brief that, number one. And number two, those damages aren't even recoverable under Daher. Daher says you can't recover for lost wages. You can only recover for loss of support. Well, Mr. Freeman wasn't providing for his family. His family had to provide for him in terms of the provision of this care. So that's point number one. Point number two.
But you don't think she's got any avenue, as it were, to
No.
recover her lost wages under the terms of the wrongful death statute and the malpractice statute?
If we attempted to do that, or the other family members who had to take time off of work, because this was multiple people had to be coordinated before she wound up having to do it all by herself. And people lost time from work. But if we attempted to assert those claims, they'd be filing a motion saying you can't get those damages under Daher.
Yeah, too attenuated. Sure, I can totally understand it. Well, here's my beef, Mr. Gothel, with because, as you point out ably in the brief, and as I'm well aware from many other cases, of course, it's not as if attendant care provided by family members is never compensable in Michigan. In fact, I would argue, maybe the opposite, in that routinely in, for example, life care cases, a family member says, I'm going to provide part of these services. I recall building a life care plan for a injured baby, when I was an assistant U.S. attorney, and, the family was going to take care of the baby, but we all agreed the family member was entitled to some compensation because, not at the rate that an LPN would be, or an RN would be compensated for providing that, but at least at the rate of, something above minimum wage, because, you are there and you have to be able to do what the individual needs when they're receiving 24/7 care. There's no doubt about that. However, it appears to me that what's happened here is that in response to a different problem, the proverbial insurance company and providers beef between what's on the charge master and what's actually reimbursed or payable, this question of phantom billing. Our legislature's passed a statute, and we may be wrangling with what I would refer to here as unintended consequences in the world of attendant care, because of course, when attendant care is provided, as it was here, it would be very unusual. It's not unheard of, particularly like in a no-fault case where people know they can get attendant care. They at least scratch down on a piece of paper, hey, I worked 16 hours this week doing attendant care, that was my the no-fault statute's also helpful in that it provides at least a glimpse into what the value of those services might be, and caps them, I think, at 16 hours a day or some such thing that you can get. But nonetheless, here, we don't have any of that guidance. All I got is this statute that says if you're going to prove up these damages, you better show a bill or actual liability. Well, I also did healthcare fraud at the U.S. Attorney's Office, and I can tell you that the document you provided as number 5 there, isn't ever going to get reimbursed by any. Certainly, no governmental entity would pay on that,
but that's not the issue, Your Honor. That's not the issue, and the law says. I mean, we have had. There's been no accounting for the robust body of law in this state that acknowledges, number one, family care services are compensable medical expenses. That's established law. Number two, the issue isn't, for this motion hearing, the issue isn't, well, how much should they be compensated? That's for the jury to determine after the taking of evidence. And there has been no argument here about what the reasonable value of those services were. That's an issue that has to be hashed out at trial based on the proofs that are presented.
And you're throwing out a number there. I mean, this 968, 628, that my understanding is that's derived from your expert life care planner's estimate on both past care and future care.
No, not
Just
future care, because there is no more future care. In the original life care plan, yes, there was a very substantial item, over $3 million for future nursing and attendant care services that this man would have required. Now that he's dead, there are no more future damages. So all we're dealing with is a finite period of time. And what the life care plan did was present a mechanism for the evaluation of those services that is consistent with Michigan law. And it's, they can make all kinds of arguments that, well, she wasn't a licensed LPN or whatever. But the law is, and that's stated in multiple cases here. This Tanowski case, the malpractice case that I cited, that acknowledged legal liability for these services, family provided medical care. The Bonkowski state case said that family members entitled to reasonable compensations for services they provide at home for an injured person in care of need, and it's up to the jury to make that determination. And in this case, in 1482, we're not dealing with the component of what was actually paid. We're dealing with the remaining component of medical expense care for which the estate remains liable. And once those services are performed, the law is clear, once those services are performed, they become an expense for which the estate is liable.
Now, we're tossing out liability and estate, pretty freely here. Are you saying that if there is a probate estate now open or to be open for Mr. Freeman, there's going to be a claim asserted in that probate estate by these family members for compensation?
Well, sure. I mean, it's all part of, there is an estate open, number one, right?
Makes sense.
Yeah, so there's an estate open. We had to do that. But what we're attempting to do is to assert these as an item of medical expense damages under the confines of the wrongful death statute and under 1482. There's nothing in either of those statutes that prohibits our request to recover for these type of damages. Period, end of story. And for them to say that these are phantom damages and that we're trying to reap a windfall recovery, that has nothing to do with this case. There's nothing phantom about the fact that these people were at this man's bedside for 24 hours a day, 7 days a week. And the issue that the jury needs to determine is what's the reasonable value of those services. And that's consistent with what Michigan law says.
All right, very good. I'll allow a brief response, Mr. Anderson.
Thank you, Your Honor. Again, going back to what counsel initially said, that the lost wages issue is not available under Daher, not for past lost wages. I mean, for example, Daher was talking about lost earnings capacity moving forward for a decedent primarily. And what we're saying is an actual damage or an actual financial loss would be the loss of earnings the family members experienced for caring for Mr. Freeman, not the value of what a life care planner's, home health aid values and LPN and RN care values are. And
well,
again,
and I guess my question then becomes to you, Mr. Anderson, when family members provide care, specifically in malpractice cases, because this subsection, this statute we're dealing with is unique to malpractice cases, is this a category of cases where unless they say, by golly, I know I'm not a LPN or whatever, but my time's worth something, my regular job pays me $20 an hour. It must be $15 an hour for sitting here at Bedside, and records that, kind of like a real care provider would on a timesheet and ascribes a value to it, based on, some valuation of their time. Unless they do that, and unless they then I don't know how you would do it if you would just create a stack of payable accounts payable for your family member there and just stack them up. awaiting the outcome in a suit, is that the only way or could they even recover that way? If they do it that way, they're still not a medical care provider. They're the best they're doing is they're saying, hey, I'm a family member who's been trained in some aspects of care, and let's be real, Mr. Freeman, I don't know, of course, you haven't gotten down to the weeds of the case, but the limited amount I see, he did need some 24/7 care, and the family member, by default, Mr. Gothel brings this up. Boy, poor people can't afford a tenant care. Well, I don't think rich people can afford a tenant care either. I don't think much insurance covers it. I think a lot of times it is provided. Are family members just stuck in medical malpractice cases?
Well, it depends on the facts of the case, Your Honor, I suppose. But I mean, it goes back to whether it's an actual damage and it's an economic loss. Again, there's a difference between projecting future damages, like if in your example where the parent's going to care for the child or
Yeah, and
whatever.
in that case, I think, right, that's a little different, right, a little different world. Yeah.
Yeah. So, I mean, like I said, the statute is very clear and it's meant to restrict economic damages to what is actually lost and to make the plaintiff whole rather than provide a double recovery here. And, that's really what we're resting on here is there's already a lien. There'll be an assertion for various other types of damages. And to the extent, plaintiff wanted to compensate the family members, they could be added, or Mrs. Freeman is no longer a plaintiff in this case, but when she was a plaintiff in this case, she could have asserted a claim for her lost wages because that's an actual loss, and an economic loss, not a hypothetical loss based on some need that is applied retrospectively for past damages. So that's our position,
Yeah.
Your Honor, is that
Yeah,
the
I
wrongful
understand.
death
And the
act.
double recovery concern you are as well, you probably shouldn't be able to get wage loss because you're away from your other job. Or if you do, it certainly would have to be offset by any amount that a court or a jury awarded compensating you for attendant care, in that you're saying, well, I couldn't be at my job because of the attendant care. Of course, if the person's, I don't know, a hedge fund manager in their day job, and they then decide to do bedside care for $12 an hour. I imagine that would be a significant difference. And then you've also got probably the more common situation where a person does something, where they're reasonably paid at $20 an hour, and they decide I'm going to do this bedside care, which we know that when we pay CNAs and stuff. Sometimes they don't even make $20 an hour. So nonetheless, yeah, there are economic differentials that need to be worked out. But you're saying, the limitation of the statute, intended or unintended, of course, it's unintended by the legislature. Then we get into the world of legislative intent. But nonetheless, would be to tighten the screws, as it were, in medical malpractice cases to provable economic loss. I think Mr. Goldhill's making a good point here that he says, well, I can prove that, Judge. I can, put out there the number of hours. Now, I don't think that exhibit attached necessarily does it, but, at a jury trial, I could get out there and say, folks, I was at the bedside. Here's how it works out, per day it is, and I should be compensated for it, and I should be allowed to put that in front of the jury. I don't think this has been necessarily, addressed in as many words since the passage of the statute. I don't think that the Nelson case hits it square on the head because it deals with a separate issue. So I'm going to take it under advisement. I'm going to reread Nelson and the statute, and I will issue a written opinion unless either party feels the need to supplementally brief what we've done today.
Your Honor, the only thing that I'd like to say is their entire argument this morning, which is somewhat, it wasn't stated in their brief, they've now conflated wage loss with the reasonable value of the services these people provided. And they're
Well, I didn't take it as that, Mr. Gothel, but I took it as, Judge, you're not leaving, because, my fundamental question is, as a family member who makes all these sacrifices for love, or I'm guessing in most cases, this is done for love, not for money. When you attend to a loved one who needs medical care, and you do that, are you completely out of luck? And I think Mr. Anderson's answer is, well, no, you can, if you lose a job like your spouse did in this case, then you can put that as a part of the death claim because that's an economic, calculable amount. And I understand you disagree that case law would, limit their ability to get that. But I think, he's saying that in this case, because of the nexus between the care needed and her, clearly, if you look at the history there, well, she took medical leave as long as she could, and then lost the job after she ran out of leave, which is reality in the workforce. Then she comes up with a number that she lost from her usual occupation that then can be calculated. Vice, but I think you're saying, on the other hand, Judge, that we should be allowed to calculate the amount that she spent at Bedside there, and then the jury should be able to determine, a reasonable hourly wage for this person who's not doesn't have any letters after her name medically, but nonetheless performed all these undoubtedly medical services for the individual. Does that, when you're a family member, is that just automatically in a malpractice case done for free, or is there a mechanism by which they can recover? And I think you've articulated that you believe there is a mechanism by which a jury ought to be able to award those damages. And I will note, as you said, they are awarded in other types of cases. It's just less than clear to me whether or not this new, relatively new statutory language inadvertently closed the door, or maybe advertently. I don't know. As you know, our medical profession is it got considerable political sway in the state, so perhaps they intentionally closed the door on these folks that are doing it. So nonetheless, I do think it's worth a written opinion because it's a fairly novel question.
Thank you, Your Honor.
Thank you, Your Honor.
Gentlemen.